Hey. Does that roll down? It's dark. Alright. You got your driver's license? Alright. The reason why I pulled you over is you didn't stop at the stop sign. She was shocked as to why she got pulled over.
She was?
She didn't even see that that was a stop sign, apparently. She's like,
On January 16, 2022, in Camden County, Georgia, a routine traffic stop for a minor stop sign violation became the catalyst for a total collapse of constitutional policing. What began as a deputy's attempt to enforce the law ended with her being indicted on 6 criminal counts, including aggravated assault and making a false statement.
hey, Dawn. Miss Dawn. Hey. Come on, step out here for me. Because I want you to. Because I'm going to talk to you.
I can't touch you right now.
No, I want you to step out.
I'd like to take the vehicle if there's a reason why.
Yeah, I want you to step out.
But there's not a reason for me to
Because
step
I
out of the
told you to
vehicle.
step out. Okay? So let's not. I want you to step out because I need you to step out. Okay?
I need to have a reason to
You
step
don't
out.
have to. Where is it stating that you have to have a
back over here,
Yeah,
please?
come on.
Ma'am,
Get out. Get out of the car.
you're really a false alarm.
11:59 camera. I need another unit.
Morning, you en route?
Get out of the vehicle. I am not. I will break this window.
You need them 1018?
She won't get out of the car. Get out of the car, so I'm going to break that window.
You're not going to break the window.
18 Cam and I'm mobile. I'll be to her in 30 seconds.
Get out of the vehicle.
59, you have to shell on 40.
Get out of the vehicle right now.
This case presents a chilling legal paradox. When does command presence cease to be a tool for safety and start becoming a mechanism for battery? As we analyze the footage, note the manner in which authority is weaponized against a non-combative citizen.
Oh my God.
7196 delay.
Listen to me. I really don't want to break your window. I really don't. But when I tell you to get out of the vehicle, you are to get out of the vehicle. So get out of the vehicle.
Load 18 is 23.
Are you kidding me?
Stop sign.
Get out of the vehicle right now.
Officer just hit the damn front of the vehicle.
Get out of the vehicle. Get out of the Get out! Right, get the out of my fucking car. Get out of the car. Get out. Are you kidding me? Get out.
Taser, taser, taser!
Get out.
Roll over, now!
Get out. Dad! Put on stop! I got him and fell.
Man.
Oh my God! They're gone.
Let him go.
You're not going to get up. Get up. That's the way I'll get up.
Hold on to her.
I put my shirt down. Get up. Right now.
All right, you're all right. Come here.
No,
You take her.
Come here!
Please.
Walk or I'm gonna drag you. Stop. I'll talk to you in a minute, but the way you act right now, we have to put our hands on you. Listen to me.
Sure, you
Stop.
just got here.
I know, and that's when I'm gonna figure it out, and then I'll talk to you.
She threw me
Stop.
on the damn floor.
Okay?
I'm
Stop.
happy that you got me. Relax.
Okay.
I'm calm.
All right.
I'm calm. She threw me on the floor. I just
down.
need somebody that's not her.
All right. I got you now. Sit down.
Was this officer de-escalating a threat, or was she manufacturing one to justify her own loss of control? To understand how a simple request to exit a vehicle led to a career-ending felony indictment, we must examine the dangerous intersection of officer ego and the Fourth Amendment.
All right.
Put your feet in, watch your head.
Can I get this?
Watch your head.
Can I get with this? Hold on. Let's get my arm off. I can't get my...
1095, Taser Point. Supervisor here. Already en route.
This one's got me all...
418, y'all need a pause. Not yet.
You hurt?
I'm not sure yet.
Are you anything hurt you? You want medical attention?
My face hurts when it kind of hit the
front of the vehicle?
The ground and then the front of the vehicle.
Okay. I'm going to call you a squad, okay? Pain in the face. Alright, you got an ambulance on the way for you, okay? You good?
Yes.
I was coming.
I know. I don't know where that came from. Honestly, she would not get out of the car.
You do what you got to do, okay?
No,
she was non-compliant. You did what you had to do to get in.
I think it hurt her when she was in cuffs.
Okay. Was she still resisting you in cuffs?
She kept saying for me to get away from her and stop. Yes, to me she was.
Okay. Well, I mean, you can tase somebody in handcuffs if they're still
I didn't
resisting.
tase her. I went hands on her, and I kept saying, I don't want to break your window. But come on, I don't understand this. I don't want to break your window. I didn't break it.
My camera's still hot.
No, I could have.
You don't have to say anything, okay? Wait till Todd gets here, all right? Talk to him, see what he says, all right?
Observe the initial interaction. Legally, the stop for OCGA 40/6/72 is valid, establishing the deputy's initial jurisdiction. However, the legal significance of the encounter shifts the moment Newman discovers Faria's suspended license. Rather than informing the driver of her status and the subsequent legal necessity to impound the vehicle or secure the driver, Newman immediately issues a command to exit.
Anything in the vehicle or anything, right?
Okay. There's nothing.
I don't understand if it's just a suspended license or something.
She didn't even know that yet. I hadn't even had a chance to tell her.
I'm thinking there might be something else.
I just asked her to step out because I just wanted to talk to her. And she said there's no reason to. I said, yeah, I just want you to step out. And she said no. She hurt.
She's saying she don't know. She thinks she might have hurt her face when she threw her around or she hit the car. But she's not even saying if she's for sure hurt or not. So.
Things okay now, I'm here?
Yeah.
Everything good? Nice mustache, go there whistling at you. How you doing,
So, you want to talk to her? She was refusing to get out of the car or whatever, and I guess Christy had her hands on her. She ended up on the ground, hit her head on the concrete. Also hit her head on the front of the push bar, so okay. She might have some head injury.
How you doing, ma'am? My name's JD. Are you hurt anywhere?
It must be my day.
What happened?
So I pulled her over for right at the stop sign. She rolls down the front window. She would only roll down the window just a little bit in the back, but I could see in there, and I had seen her front way, so I knew that there was only one person in it. I go up and said, "Hey, you got your driver's license?" And she handed me it. And I said, "Okay, the reason why I pulled you over," and because she didn't ask me, I said, "The reason why I pulled you over is that stop sign." She kind of looked at me. I said, "Yeah, usually it yields." And she says,
Technically, under the precedent set by Pennsylvania versus Mimms, an officer possesses the authority to order a driver out of a vehicle during a lawful stop without further justification. Yet legal experts often debate the spirit of Mimms. Is it a shield for officer safety or a sword to compel blind obedience? In this instance, Newman's failure to provide a basic explanation, a simple statement that Faria was no longer legally permitted to operate the vehicle, transformed a routine administrative issue into a battle of wills.
I walked back here, I thought that she was suspended. I was like, yeah, it's on judgment, what is it for, da-da-da-da. Well, I like to get them out of the car to talk to them about it. So her windows rolled down a little bit like that.
She by herself?
And I said, hey, I called her by her first name because I couldn't pronounce her last name. She ignored me, so I walked up there and I said, hey, go ahead and step out for me. She said, why? I said, because I want you to. I want to talk to you a minute. Why? I'm not going to. So she said, I want to sit here. I said, no, ma'am, I want you to step outside of the vehicle. She's suspended. She's not supposed to be in her anyways, right? So I just want her to step out here. And she said, no. She rolled up all the windows and locked them. I finally got in the back, and I said, please don't make me bust your window down. I don't want to have to do that to you. It's not that crucial. Please. He comes. She unlocked the door, got on the FaceTime with her dad. And he comes over, he says, Taser, Taser. I back up. Then I start grabbing her out. You know, like she's holding on to the Taser.
Okay.
And I mean, I could have, but I just wanted to get her out of the car. I just don't ever think about that first. So I get her to the ground and I break her and I take her to the ground. We're trying to get her cuffs and Taser again. She's screaming. And I said, get up. I grabbed her. She said, she's not grabbing me like that. So I get her up. I told her, get up. So she kept like, away from me. So I grabbed her and did this, and she hit her head on the front of I mean, she just wouldn't stop. And so he told me, Christine, calm down, get away, go sit in your car because I'm shaking. She just wouldn't get out. No, I'm just shaking up.
Let me talk to you real quick. Ma'am.
Note the tactical red flag at the 2-minute mark. Newman abandons professional communication and resorts to a threat of property damage, stating she will break the window. This is a pivotal moment where command presence is replaced by emotional volatility. The civilian test reveals the disparity. Had a private citizen threatened to smash a window because their questions weren't answered to their satisfaction, it would be viewed as an attempted entry or assault. When backup arrives, the situation reaches a point of no return. Instead of utilizing the second officer to provide a cooling-off period or a fresh perspective, Newman uses the additional manpower to initiate a high-force extraction, escalating a passive resistance scenario into a violent physical altercation.
Ma'am, so she ran your license and came back suspended, all right? There's a no judgment suspension, so it's usually like child support.
It's a bill of sale for a car that I sold in the
Okay, so it's
a bill of sale.
It's usually nothing that we really care about that much. So she was asking you to get out of the vehicle, so you explained to you can't drive, and you refused to get out of the vehicle. So she was, instead of taking you to jail for suspended license, she was actually just going to give you a citation for wherever her original stop was and let you go. But then you refused to get out of the vehicle.
All I wanted was for her to give me an information on why I need to get out of the vehicle. Because
she doesn't owe you that explanation.
When she stopped me, she originally said the reason I stopped you was because of the stop sign back there. And I said, okay.
Oh.
So that
when we tell someone to get out of the car, we don't have to give them a reason right then and there.
We don't want to tell you, oh, we're going to have you get out of the car because we see a gun right there.
Or, hey,
separate you from the, and then obviously you reach down for the gun.
It was not a hostile situation.
Well, she doesn't know that. How is she supposed to know that?
Or like saying, hey, you know, you got like several felony warrants for murder. I'm not going to tell you, hey, get out of the car, you got warrants for murder.
To dismantle the legal components of this incident, we must look at the specific indictments handed down by the grand jury. The most striking is the charge of making a false statement under OCGA 16/10/20. Newman's official report claimed Faria jerked her arm in an attempt to resist arrest. However, the forensic clarity of the video evidence reveals no such movement, only a citizen being violently manipulated. This raises a fundamental question about systemic integrity. If the dashcam didn't exist, would this fabrication have become the official truth? Furthermore, the charge of aggravated assault under OCGA 16/5/21 stems from the repeated deployment of the taser on a subject already neutralized on the pavement. Under the Fourth Amendment, any use of force must be objectively reasonable, as established in the landmark case Graham versus Connor. When an officer utilizes a weapon to punish non-compliance rather than to secure a genuine threat, they transition from a protector of the peace to a perpetrator of battery.
To understand why this is so severe, we must examine the 3 counts of violation of oath of office under OCGA 16-10-1. In Georgia, this charge acknowledges that the damage done isn't just physical, it is a breach of the sacred trust between the state and the governed. Legally, an officer's authority is conditional upon their adherence to the Constitution. When that oath is discarded to satisfy a personal impulse, the authority itself becomes illegitimate. The fallout of this incident serves as a grim reminder of how quickly the legal system can be weaponized through a culture of Testilying, where official reports are tailored to fit a narrative of resistance rather than the observed reality. Systemic failure occurs when an agency's internal culture allows an officer to believe that a body camera can be overwritten by a sworn statement. To understand the gravity of this systemic failure, we must consider the potential outcome if this footage had been lost or malfunctioned. A citizen would have been buried under felony charges, effectively silenced by the weight of a fraudulent report. This leads us to a critical legal issue regarding citizen survival during traffic stops. While it is tempting to demand a reason before complying with an order to exit, the roadside is not a courtroom. Under the Mimms precedent, once the command is given, the legal threshold for obstruction is met the moment you refuse. For the citizen, the lesson is clear. Comply with the order to exit to strip the officer of their excuse for escalation. You cannot win a physical battle against a badge on the street. You win the legal battle against the person behind it in court, where the evidence, not the ego, defines the truth. Final verdict. Deputy Christine Newman receives a grade F. While Newman possessed the initial legal authority to stop the vehicle and order the driver to exit under the precedent of Pennsylvania v. Mimms, her subsequent conduct was a catastrophic failure of both ethics and law. By escalating a passive interaction into a violent assault and then intentionally falsifying an official report to manufacture criminal charges against a citizen, she abandoned her role as a peace officer. Her indictment on 6 criminal counts and her termination represent a rare but necessary moment of accountability for a total betrayal of the public trust. Karis Faria receives a grade C-. It is a harsh reality of American law that a driver must comply with an order to exit the vehicle during a lawful stop, even if the officer is being unhelpful or hostile. By refusing the order and attempting to litigate the matter on the roadside, Faria technically committed the act of obstruction, providing the legal hook the officer needed. However, her resistance was purely passive and nonviolent, and it in no way justifies the brutalization or the perjured report that followed. Faria was a victim of an officer who chose ego over the Constitution. The Camden County Sheriff's Office and the GBI receive a grade A for their handling of the aftermath. By reviewing the footage objectively and pursuing felony indictments against their own, they demonstrated that transparency is the only cure for police misconduct. What do you think? Does the driver's initial refusal to exit the vehicle mitigate the officer's actions, or was the deputy's response a criminal assault from the moment she reached for her taser? Let us know in the comments below.